529. The subordinate courts consist of the session courts and also the magistrate courts. The session courts and the magistrate courts have a general jurisdiction in both civil and criminal matters. In addition, both courts are exist in each state in Malaysia.
Assalamualaikum and good day I bid to everyone viewing this video, especially to my dearest lecturer Dr. Anis Shuaiza. My name is Aina Husna Azan Hawari, and today I will be presenting on one of the subordinate courts in Malaysia, which is the session courts. For starters, I will explain the composition of the session courts. Generally in Malaysia, session courts are established under Section 59 of the Subordinate Courts Act 1948, which reads, "The Yang di-Pertuan Agong may by order constitute as many session courts as he may think fit and to assign local limits of jurisdiction." Furthermore, every hearing is presided by a sessions court judge sitting alone, which is appointed by the Yang di-Pertuan Agong on the advice of respective chief judges. Proceedings in session courts are conducted every day except on public holidays. Session courts have original jurisdiction in both criminal and civil matters, along with supervisory jurisdiction. Under the original jurisdiction regarding crimes, Section 63 of the Subordinate Courts Act establishes that a session court has criminal jurisdiction to try all offences except those which are punishable by death. Other than that, Section 64 of SCA also implies that session courts have the authority to pass any sentence allowed by law apart from death sentence. As for civil matters, session court has the jurisdiction as laid down in Section 65 until Section 70 in the SCA. According to Section 65, subsection 1A, session courts have unlimited jurisdiction for matters which are motor vehicle accidents, landlord and tenant, and distress. Other actions of civil nature, session courts cover matters where the amount in dispute or subject matter value does not exceed 1 million ringgit, as mentioned in Section 65, subsection 1B. Apart from that, the session court has jurisdiction to try all suits for specific performance, rescission of contract, or for cancellation or rectification of instruments within its jurisdiction, which is highlighted in Section 65, subsection 1C. According to Section 65, subsection 5A and B, Session Court has the authority to grant injunction and make a declaration whether or not any other relief, redress, or remedy is or could be claimed. On the other hand, Section 69 of the SCA has justified several matters that are beyond the Session Court's jurisdiction. Those listed under Section 69, subsection A until subsection K are generally actions that are likely to raise difficult points of law which are best to be heard in high courts. The matters enumerated are as the following: relating to immovable property except as provided in Section 70 and 71, for the specific performance or rescission of contracts, for an injunction, for the cancellation or rectification of instruments, and to enforce trust. For accounts, for declaratory decrees except in interpleader proceedings under Section 73, for the issue or revocation of grants of representation of the estates of deceased persons or the administration or distribution, wherein the legitimacy of any person is in question, wherein the guardianship or custody of infants is in question, and last but not least, wherein the validity or dissolution of any marriage is in question. So, the question here is, what happens if the issue brought to court is beyond the session court's jurisdiction, wherein any action or suit any defense or counterclaim of the defendant involves matters beyond the jurisdiction of the Session Court, there would be two solutions, which one of them would be: the court may nevertheless proceed to determine the plaintiff's claim and the defense or counterclaim raised, but no relief in excess of the court's jurisdiction may be awarded to the defendant on the counterclaim. An alternative solution would be either party may apply for the case to be transferred to and tried in the High Courts. The Session Courts are vested with a limited supervisory role over the magistrates and Penghulu's court. A Session Court judge may call for and examine the record of any civil proceedings before the magistrate or Penghulu's court within the local limits of its jurisdiction to satisfy himself or herself as to the correctness, legality, or propriety of any decision recorded or passed, and as to the regularity of any proceedings of that court. If any judge of the Session Court is of the view that any decision of the magistrates or Penghulu's court are illegal or improper, or that any such proceedings are irregular, he or she must forward the record with such remarks as he or she thinks fit to the High Court. The High Court may give such orders that are necessary to ensure that justice is prevailed. Last but not least is regarding appeal proceedings of cases from the Session Courts. Appeals from Session Courts in both civil and criminal matters will proceed in the High Courts.
A very good day to all my friends and Dr. Anis. I'm Su Dongjiang and my membership number is 288551. So today I would like to present about the Magistrate Court on behalf of Group 10. Magistrate Court is one of the subordinate courts in Malaysia. A magistrate may either be a first-class magistrate or a second-class magistrate. By virtue of Section 78 of Subordinate Courts Act (SCA) 1948, a first-class magistrate for the Federal Territory is appointed by the Yang di-Pertuan Agong based on the recommendation of the Chief Judge, whereas a first-class magistrate for the state is appointed by the particular state authority based on the recommendation of the Chief Judge. The first-class magistrates belong to the Judicial and Legal Service, and pursuant to Article 132 of the Federal Constitution, they are public servants of the Federation. By virtue of Section 79 of SCA 1948, a second-class magistrate for the Federal Territory is appointed by the Yang di-Pertuan Agong, whereas the state authority may appoint a fit or proper person to be a second-class magistrate. Magistrate Court has only original but not appellate jurisdiction for both civil and criminal cases. Pursuant to Section 19 of SCA 1948, a first-class magistrate may hear a civil case when the amount in dispute does not exceed 100,000 ringgit. A second-class magistrate, however, shall only have the jurisdiction to try original actions in order to recover debt or liquidated demand in money with or without interest not exceeding 10,000 ringgit, pursuant to Section 92 of SCA 1948. However, the Magistrate Court may also try small claims action of less than 5,000 ringgit as pursuant to Order 93 of Rules of Court 2012. According to Section 93 Clause 1 of SCA 1948, Subsection 65 Clause 3 and Clause 4 and 66 to 70 and 72 to 74 relating to the powers and jurisdiction of the Sessions Court shall apply mutatis mutandis to the Magistrate Court, provided that for the purpose of proceedings in the Magistrate's Court. Paragraph 73, Clause B shall be read as if the words 100,000 were substituted for the words 1 million. Therefore, a magistrate court can also hear a case concerning immovable property, but only if there is no bona fide dispute of title, as Section 71 of SCA 1948 does not apply mutatis mutandis to a magistrate court. However, it is important to note that Section 93 does not extend the jurisdiction of the second-class magistrate, as otherwise limited by the SCA 1948. Regarding the criminal jurisdiction, pursuant to Section 85 of SCA 1948, a first-class magistrate shall have jurisdiction to try all offences for which the maximum term of imprisonment provided by the law does not exceed 10-year imprisonment, or offences which are punishable with fine only, and offences under Sections 392 and 457 of the Penal Code 1950. Previously, the first-class magistrate has also jurisdiction to hear and determine criminal appeals by persons convicted by Penghulu's court pursuant to Sections 86 of the SCA 1948, but now it has been repealed. The first-class magistrate may pass sentence allowed by law not exceeding 5 years imprisonment, a fine of 10,000 ringgit, whipping out to 12 strokes, or any sentence combining aforesaid pursuant to Section 87 of the SCA 1948. In respect of the criminal jurisdiction of a second-class magistrate, he may hear criminal matters on two natures: where the offence is punishable by a fine only, or where the offence provides for a term of imprisonment not exceeding 12 months under Section 88 of SCA 1948. Provided, however, that if a second-class magistrate believes the powers of punishment he has will be insufficient in the circumstances of a case, he shall take the appropriate procedures to postpone the matter for trial by a first-class magistrate. Moreover, pursuant to Section 89 of SCA 1948, the second-class magistrate may pass a sentence of 3 elements, which are a term of imprisonment not exceeding 6 months, a fine not exceeding 1,000 ringgit, or any sentence combining aforesaid. In addition, the second-class magistrate can replace the first-class magistrate in the absence of the first-class magistrates in practice. There are exceptions where the magistrate may exceed its sentencing jurisdiction. The first exception is that provided under Section 87 Clause 1 of the SCA 1948, where a first-class magistrate may award a full punishment for any offence in excess of the power prescribed by the section as authorized by other laws for the time being enforced. For instance, Section 118 of the Custom Act 1967 provides that a first-class magistrate is empowered to try any offence under the Act and to award the full punishment for any such offence. Section 41 Clause 1 of the Dangerous Drugs Act 1952 also provides that a first-class magistrate is empowered to try any offence under the Act, except under Section 39B, and a magistrate may impose punishment provided by that offence on the condition that if the punishment is imprisonment, it cannot exceed for 5 years. Another exception is provided under Section 87 Clause 2 of the SCA 1948, where if a magistrate has convicted any person and it appears that by reason of any previous conviction, a punishment in excess of that prescribed by Substitution Clause 1 should be awarded, then the first-class magistrate may award the full punishment authorized by law for the offence of which the person has been convicted and shall record his reason. This is illustrated in the case of Degu Hitang vs. Public Prosecutor 1962, where the court said that the provision of Section 87 Clause 2 of the SCA 1948 should only be invoked when the cases take an expected turn and the evidence so adduced shows that the maximum sentence that can be imposed by the trial magistrate is inadequate. Local limits of jurisdiction for magistrate court are assigned by Yang di-Betul Agong by virtue of Section 76 Clause 1 of the SCA 1948. If none has been assigned, the magistrate court shall have jurisdiction for any cause or matter arising in any part of Peninsular Malaysia. So far, since there is no assignment, the magistrate court in Peninsular Malaysia will have jurisdiction to hear any cause arising in the Peninsular Malaysia, and the magistrate court in Sabah and Sarawak will have jurisdiction to hear any matter arising in Sabah and Sarawak. However, this is subjected to provisions under Section 99A and 3rd Schedule of the SCA 1948. Pursuant to Section 99A and Paragraph 2 of the 3rd Schedule of the SCA 1948, the subordinate courts have power to stay proceedings unless they have been instituted in the district where the cause of action arose or the defendant resides or has his place of business, one of the several defendants resides or has his place of business, the facts of which the proceedings are best exist or alleged to have occurred, or other reasons in the interest of justice. Pursuant to Paragraph 3 Clause 2 of the 3rd Schedule, the magistrate court can also transfer proceedings to another court of coordinate jurisdiction or obligation of parties or of its own motion. To summarize, I have presented about the appointment, the civil and criminal jurisdiction, the exception to exceed sentencing jurisdiction, and also the territorial jurisdiction of the magistrate court. So that's all from me. Thank you for lending me your ears.
To continue further our discussion, my name is Farah Najihah binti Zulhisham. So I'm going to bring you the Subordinate Courts Rules Act 1955. This is an act for regulating and prescribing practice and procedure in proceedings in the subordinate courts in Malaysia, which consists short title, interpretation, establishment and constitution of rules committee, duties of committee, application, rules applicable to government suits, powers vested in committee, and last but not least, rules to be laid before Dewan Rakyat or to be called as House of Representatives. To conclude, understanding basic jurisdiction of the court is important in upholding your client's interests. Such understanding may be useful where your opposing party makes a mistake in respect of the court's jurisdiction. The legal point that a court has no jurisdiction to hear a matter or grant the relief's claim is one that goes to the root of the matter and can severely damage one's case. The Malaysian legal system is a relatively young one, barely over half a century old. The courts have had to deal with complex issues arising out of an evolving legal system over the past 50 years, but there remains much to be developed. The next generation of the Malaysian judiciary will need to continue to decide and clarify issues that will invariably arise over the coming years. In order to do so, an independent and impartial judiciary is vital. Meaningful development of the legal landscape is dependent on respect for the separation of powers on the part of the other branches of government as well. The evolution of the legal landscape as Malaysia moves forward in the 21st century will hopefully be guided by the approach that is true to the spirit of the Constitution and the safeguarding of the fundamental liberties enshrined therein.